Question number 101. Which of the following is false of section 34 and section 149 of IPC? Option A. Section 34 does not by itself create any specific offence, whereas section 149 does so. Some active participation in crime is required in section 34 while it is not needed in section 149. Section 34 speaks of common intention while section 149 contemplates common object. D. Section 34 requires at least 5 persons who must share the common intention while section 149 requires at least 2 persons to share the common intention. In this question, it has been asked which of the following is false of section 34 and 149. So the statement D is false, therefore the correct answer. The difference between section 34 and section 149 of IPC is that option A, whereas in section 34 there must be at least 5 persons, section 149 requires only 2 persons. Section 149 is only rule of evidence, whereas section 34 creates a specific offence. Section 34 creates active participation in action, whereas section 149 requires mere passive membership of the unlawful assembly. D, both B and C. Here the correct answer is option C. Section 34 requires active participation in action, whereas section 149 requires mere passive membership of unlawful assembly. Question number 103. Distinction between section 34 and 149 of IPC has been authoritatively expounded by the Supreme Court in. Correct answer is Nanak Chand versus State of Punjab. Question number 104. The difference between section 34 and 149 of IPC is option A, that whereas in section 34 there must be at least 5 persons, section 149 requires only 2 persons. Option B, the section 149 is only a rule of evidence, whereas section 34 creates a specific offence and provides for its punishment. Option C, that section 34 requires active participation in action, wherein section 149 mere passive membership of the unlawful assembly is sufficient. Option D, that section 34 need not be joined with the principal offence, whereas section 149 must be combined with the principal offence. In question number 104, the correct answer is option C, that is that section 34 requires active participation in action, whereas section 149 is mere passive membership of the unlawful assembly is sufficient. Question number 105. X armed with loaded pistol and Y empty-handed go to Z shop in furtherance of their common intention to commit robbery. X enters the shop and on being resisted in carrying away property shoots Z with pistol. Z dies at once. For what acts of X and Y is liable? Options are dacoity with murder. Option B, extortion and culpable homicide not amounting to murder. Option C, attempt to commit robbery with armed with deadly weapon, and option D, robbery and murder. Here the correct answer is option D, that is robbery and murder. Question number 106. X and Y go to murder Z. X stood on guard with a spear in hand but did not hit Z at all. Y killed Z. In this case, option A, only Y is liable for the murder of Z. Option B, X and Y both are liable for the murder of Z. Option C, X is not liable as he did not perform any overt act, and option D, both A and C are correct. Here the correct answer is option B, that is X and Y both are liable for the murder of Z. Question number 107. X, a jailer, has a charge of Z, a prisoner. X, intending to cause Z's death, illegally omits to supply Z with food, in consequence of which Z is much reduced in strength, but that starvation is not sufficient to cause his death. X is dismissed from his office and Y succeeds him. Y, without collusion or cooperation with X, illegally omits to supply Z with food, knowing that he is likely to thereby to cause Z's death. Z dies of hunger. What will be the position under IPC 1860? Options are X and Y are guilty of murder. Option B, X is guilty of an attempt to commit murder, and option C, Y is guilty of an attempt to commit murder, and option D, Y is guilty of an attempt to commit culpable homicide. Here the correct answer is option B, that is X is guilty of an attempt to commit murder. Question number 108. A intentionally causes death partly by illegally omitting to give Z food and partly by beating Z. A has committed the offence of option A, culpable homicide not amounting to murder, B, attempt to commit murder, C, murder, D, grievous hurt. Here the correct answer is option C, that is murder. Question number 109. How many kinds of punishments are provided in section 53 of IPC? Correct answer is 5. Question number 110. Which of the following punishment cannot be awarded under IPC? Options are forfeiture of property, rigorous imprisonment, transportation of life, and option D, death. Correct answer is transportation for life. Question number 11. Question number 111. Death sentences should be awarded in rarest of the rare cases was held in. Correct answer is Bachchan Singh versus State of Punjab. Question number 112. By which one of the following acts the words imprisonment for life were substituted for the words transportation for life in the IPC? Correct answer is option C, that is Act 26 of 1955. Question number 113. Under which of the following sections of IPC the death sentence can be commuted without the consent of the offender? Options are section 53, section 55, section 54 or none of these. Correct answer is option B, that is section 54. Question number 114. Commutation of sentence of imprisonment for life is done under IPC in option A section 52, B section 53, C section 54, D section 55. Correct answer is option D, that is section 55. Question number 115. Who may commute sentence? Options are Chief Justice of High Court, Chief Justice of India, appropriate government, any appellate court. Correct answer is appropriate government. Question number 116. The appropriate government may commute the sentence of death of an accused person to any other sentence. Option A, with the consent of the accused. Option B, with the consent of the relatives of the accused. Option C, with the consent of the advocate of the accused. None of the above. Correct answer is option D, that is none of the above. Question number 117. In how many years a sentence of imprisonment for life can be commuted by the government? Option A, 20 years, B, 18 years, C, 14 years, D, 12 years. Correct answer is option C, that is 14 years. Question number 118. In calculating the fractions of terms of punishment, section 57 of IPC prescribes that imprisonment for life shall be reckoned as equivalent to the imprisonment for option A 10 years, B 14 years, C 20 years, D 25 years. Correct answer is 20 years. Question number 119. Where is no sum is expressed to which a fine may extend, there the amount of fine to which the offender may be liable will be option A not exceeding the rupees 50,000, option B not exceeding rupees 25,000, and option C not exceeding rupees 10 lakh, and option D unlimited but not expensive. Correct answer is option D, unlimited but not excessive. Question number 120. Question number 120. Under section 65 of IPC, sentence of imprisonment for non-payment of fine shall be limited to. Options are 1/3 of the maximum term of imprisonment fixed for the offence. Option B, 1/4 of the maximum term of imprisonment fixed for the offence. Option C, 1/2 of the maximum term of imprisonment fixed for the offence. And option D, 1/5 of the maximum term of imprisonment fixed for the offence. Correct answer is option B, that is 1/4 of the maximum term of the imprisonment fixed for the offence. Question number 121. Which section of IPC provided for imprisonment for non-payment of fine when the offence is punishable with fine only? Options are section 63, section 64, section 67, option D, none of the above. Correct answer is option C, that is section 67. Question number 122. In case of an offence punishable with fine only, imprisonment for the non-payment of fine has to be rigorous, has to be simple, can be rigorous or simple, can be partly rigorous or partly simple. Correct answer is option B, that is have to be simple. Question number 123. Under IPC, if the offence is punishable with fine only and the accused has been awarded with 50 rupees fine, the period of imprisonment in default shall not exceeding 1 month, not exceeding 2 months, not exceeding 3 months, not exceeding 4 months. Correct answer is option B, that is not exceeding 2 months. Question number 124. Under IPC, which one of the following sections makes provisions for solitary confinement? Correct answer is option C, that is section 73. Question number 125. Under section 73 of IPC provides for the maximum limit of solitary confinement to be option A 1 year, option B 2 years, option C 3 months, and option D 6 months. Correct answer is option C, that is 3 months. Question number 126. If an offender is sentenced to an imprisonment for a term exceeding 1 year, the term of solitary confinement shall not exceed. Options are 1 month, 2 months, 3 months, no limit. Correct answer is option C, that is 3 months. Question number 127. The term of rigorous imprisonment shall not exceed 6 months, then the maximum period of solitary confinement shall be option A 15 days, B 1 month, C 3 months, D 6 months. Correct answer is option B, that is 1 month. Question number 128. Enhanced punishment for previous conviction under dash of the IPC. Section 76, Section 77, Section 68, Section 75. Correct answer is option D, that is section 75. Enhanced punishment for the previous conviction under section 75 of the IPC. Question number 129. Imprisonment for the life means imprisonment for 20 years, 74 years, 14 years, whole of the remaining life. Correct answer is D, whole of the remaining life. Question number 130. Chapter 4 of the IPC code deals with. Correct answer is option D, that is general exceptions. Question number 131. General exception of IPC limit and override offences and penal provisions of the code and comprises of the following sections: A. 61 to 102, B. 96 to 106, C. 82 to 106 and D. 76 to 106. Correct answer is option D, that is section 76 to section 106. Question number 132. The maxim ignorantia juris non exequat means ignorance of law is no excuse, ignorance of fact is no excuse, ignorance of law is an excuse, ignorance of fact is an excuse. Correct answer is option A, that is ignorance of law is no excuse. Question number 133. Ignorantia facet exequat maxim means mistake of law is excused, ignorance of fact is an excuse, ignorance of law is not an excuse, none of these. Correct answer is option B, that is ignorance of fact is an excuse. Question number 134. The maxim ignorantia facet exequat relates to section 75 of IPC, section 76 of IPC, section 77 of IPC, none of the above. Correct answer is option B, that is section 76 of the IPC. Question number 135. A soldier fires on a mob by the order of his superior officers in conformity with the commands of law. A has committed no offence with his defence comes under section dash of IPC. Options are section 76, section 77, 78, 79. Correct answer is option A, that is section 76. Question number 136. Assertion. A soldier fires on a mob by the order of a superior officer in conformity with the commands of law. A has committed no offence. Reason: nothing is an offence which is done by a person who is bound by law to do it. Choose the correct answer from the quotes given below. Quotes are both A and R are true and R is the correct explanation of A. Option B, both A and R are true but R is not the correct explanation of A. Option C, A is true but R is false, and option D, A is false but R is true. Here the correct answer is option A, that is both A and R are true and R is the correct explanation of A. Question number 137. For the defence of mistake of fact under IPC, option A, actual mistake is sufficient, the act must be reasonable, the act must be reasonable as well as committed in good faith, none of the above is correct. Here the correct answer is option C, that is the act must be reasonable as well as communicated in good faith. Question number 138. A, an officer of a court being ordered by the court to arrest Y and after due inquiry believing Z to be Y arrests Z. What mistake has been committed by A? Option A, mistake of fact, option B, mistake of law, option C, both A and B above, and option D, none of these. Here the correct answer is option A, that is mistake of fact. Question number 139. A police officer without warrant apprehends Z who has committed murder. A has committed the offence of option A, wrongful confinement, B, wrongful restraint, C, A and B both, and option D, no offence. Correct answer is option D, that is no offence. Question number 140. A in good faith accuses Z before a magistrate. Option A has committed no offence. Option B, A has committed the offence of defamation. Option C, A has committed the offence of defamation but he can take defence under section 93 of IPC, and option D, none of the above. Correct answer is option A, that is A has committed no offence. Question number 141. A soldier fires on a mob by the order of his superior officer in conformity with the commands of the law due to which certain persons are injured. What offence has been committed by A? Options are attempt to murder, hurt, grievous hurt, no offence. Correct answer is option D, that is no offence. Question number 142. Which of the following sections of IPC act done in pursuant to judgment or order of a court is not an offence? Options are section 78, section 79, section 90, section 91. Correct answer is option A, that is section 78. Question number 143. Which of the following statement is correct? A hangman who hangs the convict pursuant to the order of the court is exempted from the criminal liability by virtue of section 94 of IPC, section 76 of IPC, section 78 of IPC, section 77 of IPC. Correct answer is section 78 of IPC. Question number 144. A is a police officer. A court of law orders him to arrest B. After due inquiry and believing C to be B, A arrests C. In this case, is guilty of wrongful confinement, can take the defence of mistake of fact, can take the defence of authority of law. None of the above is correct. Correct answer is option B, that is can take the defence of mistake of fact. Question number 145. An act which is done by a judge when acting judicially in the exercise of any power which is or which in good faith he believes to be given to him by law, then act of judge is an offence because judge should have the knowledge of law, is not an offence, is punishable, is unpardonable, and maximum punishment should be imposed. Correct answer is option B, that is it is not an offence. Question number 146. A and B corporation officers legally demolish the illegal constructed structure of C and remove the material for safe custody. Which offence is committed by A and B? Option A, criminal breach of trust. Option B, dishonest misappropriation of property. Option C, theft, and option D, none of the above offence. Correct answer is option D, that is no offense. Question number 147. Which provision of the IPC says nothing is an offense which is done by an accident? Option A, section 79 of IPC, option B, section 78 of IPC, and option C, section 80 of IPC, and option D, none of the above. Correct answer is option C, that is section 80 of IPC. Question number 148. Which of the following is not an essential ingredient of the defense of accident under section 80 of IPC? Options are: the act must be an accident or misfortune, and option B, the act must not be done with any criminal intention. Option C, the act need not to be done with proper care and caution, and option D, the accident must be the outcome of lawful act done in lawful manner by lawful means. Here the correct answer is option C, that is the act need not to be done with proper care and caution. Question number 149. A is cutting the wood with an axe at a place where children are playing. The axe flies off and kills a nearby child. A is liable for no offense, murder, culpable homicide, causing death by negligence. Correct answer is option D, that is causing death by negligence. Question number 150. A is at work with hatchet. The head flies off and kills a man who is standing nearby. No want of proper caution on the part of A. His act is murder, culpable homicide not amounting to murder. His act is excusable, not an offense, causing death by negligence. Correct answer is option C, that is his act is excusable, not an offense.